un evento muy lindo por la posibilidad de poder compartir estas ideas en un ida y vuelta que sea una suerte de diálogo entre ellos y nosotros, para poder comprender la realidad de ellos, no solo la nacional, sino también la realidad comunitaria, para quienes son estudiantes, tengan la posibilidad de tomar un contacto real y concreto con la problemática de la internacionalización de los ordenamientos jurídicos, en una visión comparativa a América y Europa, contrastar el marco jurisprudencial de la Corte Europea de Derechos Humanos con la Corte Americana de Derechos Humanos, y en todo ello una discusión, un diálogo muy enriquecedor. Nos hace también el honor de estar con nosotros, magistrados y profesores, muy distinguidos de esta casa de estudio y de otras casas de estudio también. Aquí tenemos a la profesora Gabriela Seicas, al profesor Julián Scheller, al profesor e investigador de la Universidad de Buenos Aires, doctorado en Francia, el profesor Sebastián Curral, y todos ustedes y el resto de los amigos que van a unirse y se están uniendo a la reunión. Muy especialmente agradecer a los amigos que nos han pedido que hagamos en Zoom, amigos y colegas del interior del país y de Latinoamérica, y sin más prolegómenos, le cedo la palabra a nuestro querido profesor Fernando García Puyés, quien va a abrir formalmente este grupo. Gracias.
Gracias. Es un placer estar aquí. Es un placer. Ya la iniciativa de Jack de traer a ustedes, a ambos, que ya son ahora amigos de la casa. Y creo que es una época especialmente útil para hablar del control contencioso de la administración. En un contexto judicial o en un contexto parajudicial, del procedimiento que podemos esperar y de los derechos que están en juego en cada caso, en particular, y el derecho a un tiempo del proceso que sea adecuado para que sea la persona humana y no los intereses los que sean defendidos en el contexto administrativo. Así que solo esperar que sea lo más beneficioso para todos y darle inicio a esta jornada que solamente va a ser escuchado por ahora. Puede venir.
Dear professors, dear members of the Faculty of Law in Buenos Aires, dear students, for us it's a great pleasure to come here to share with you our experiences and knowledge about the Polish and European legal system. Thank you very much for your hospitality, for your kindness. I hope so that our meeting today will be divided into two sections. The first of it is our presentation, but of course we are open to your questions and other statements that you will tell us. We are really curious about your experiences and your evaluation of our presentation, our papers. Feel free to ask us questions what you want, and I think that we can slowly start this presentation. At the beginning, I think that it's worth to say that both of us are members of the law faculty, but also we are employed in courts. My colleague Jan is a judge in the ordinary court, civil court in Posznan, and I'm employed in the Supreme Administrative Court in Warsaw. In a few minutes, you will hear from my colleague that we have a court system in which there is a strong division between ordinary courts, That means civil, criminal, labor courts, and administrative courts. So it's not the case like in Argentina that you have special sections, but in the one system of courts, we have two separated branches, divisions of courts, administrative and ordinary. And administrative courts have their own structure with the courts of first instance and the Supreme Administrative Court on the top. And ordinary courts, these are, as I told you, civil, criminal, labor courts, and at the top of ordinary courts is the Supreme Court. Our presentation will be divided into two parts. The first part will have organizational nature. My colleague will present you the structure of the Polish judiciary and the mainly constitutional issues. And in the second part, I will try to tell you the most important things when it comes to procedure, mainly before administrative courts. So now I will give the floor to my colleague, and in the second part, we come back to the procedure. Okay. Okay.
Okay, thank you very much. Thank you for the presence here, and thank you especially for Professor Damsky for organizing this meeting. I know that we had very short time and the time was limited to organize the meeting here, but it is great pleasure to meet you in Argentina. So muchas gracias. That's only what can I say in Spanish. But anyway, it is a great pleasure for us to meet and to talk about the legal system in Poland and in Argentina, especially in the comparative perspective. As my colleague said at the beginning, can say some more general things about our faculty and about the system, legal system and judicial system in Poland. Then I will speak about the tensions between judiciary and executive power, especially. I know that in different systems in the world, there are the tensions between the judiciary and the executive power. I know that in Argentina, you have also some tensions between the judiciary and executive power. I think it is quite typical that the executive power would like to force the judiciary. And I would like to say about some examples from the case law, but at the beginning, you can see on the slide the photo of our faculty. We are from Posznan. It's between Berlin and Warsaw. It's in the middle of the way between Berlin and Warsaw, and our faculty, just a short presentation of the faculty. We have the 100th anniversary in 2019. So the faculty, the university, Adam Mickiewicz University, was founded in 1919. If we can move a little bit. Yeah, and we have 4,000 students. I know that it's not very impressive for you because Professor Damsky told us that you have 25,000 students. So it's not so big faculty of law, but from the Polish perspective is one of the most important law faculties, law school in the Polish academic society. We have 5 different programs. We have the law. The second one is the German-Polish law. It is very unique because we conduct the law program on the border between the Poland.
Específicamente, el 2 reconoce el catolicismo como religión oficial del gobierno federal, implicando que el Estado argentino reconoce y respalda el culto católico romano. Sin embargo, es importante destacar que este artículo no establece una religión oficial para la ciudad.
Connected.
La libertad de religión está garantizada por otros artículos de la Constitución.
Of course, we have also the doctoral students. We have some exchange programs, international connections. But as far as we know, we don't have a connection with Argentina. So maybe that's the first step to establish the connections between the Posznan and Buenos Aires. So that's just a quick look for our university, for our faculty. As I said at the beginning, as my colleague said also, just a short look at the legal system in Poland, which is, I think, the most important to try to understand the problems and the tensions between the executive power and the judiciary. We have the constitutional republic with the most important role of the Council of Ministers and the Parliament. So the president has no so strong position as it is in Argentina. We have the two chambers of the Parliament, the Sejm and Senate. Sejm is the lower chamber and Senate is the higher chamber. What is similar to Argentina, that we had the election last week. I know that you had the election yesterday, so we had the election last week, but that was the election for the parliament. And according to this election, probably the Council of Ministers will change in the next few weeks. We had the right-wing parliament for 8 years, from 2015 till now. And right now, it will be a different situation. The more liberal parties won the election for the parliament. So we are waiting for a little bit of change for the attitude, especially for the EU. According to judicial power, we have, as my colleague said, different situation than in Argentina. If we speak about the tribunals, we have the Constitutional Tribunal, which is a tribunal which take care about the conformity with law of the statutes which are enacted by the parliament. And we have also the Tribunal of the State, which is the special tribunal for the public entities, public persons like the president or the prime minister. And what is the most important from the judicial perspective, we have, as I said, different system of the courts. We have, in general, 3 main branches of the court: the administrative courts, which might be the most interesting for you, as the administrative law professors and administrative law students. We have the common courts, which are the most important if we speak about the numbers of cases, about the numbers of judges, and so on. And we have also the military courts. If we speak about the common judiciary, we have 3-tier system. We have at the lowest level, we have district courts, then we have regional courts, and we have also the appellate courts, and the common courts are headed by the Supreme Court. So that's the branch of the common judiciary. Different situation is about the administrative court. We have 16 voivodeship administrative courts. We have 16 provinces in Poland, and every province has its own voivodeship administrative courts. And administrative courts are headed by the Supreme Administrative Court. So that's the point. If we speak about the court proceedings, I will speak more or less about 3 main things. The first thing is defining the aim of functioning the judiciary from the perspective of authorities, which are the most important from the organizational point of view. So what is the aim of judiciary? Of course, the aim of judiciary from the first perspective is the right to fair trial for the citizens. But we have to think how it looks like from the authorities which are heading the judiciary. The second, and I think that it is most interesting view, is the perspective of judicial activities versus court administration. So how court administration can affect the judicial activities. Of course, the most important is the independence of judiciary. and how it might be interfered by the by the administration of judiciary. The second thing is the principle of separation of powers. So, of course, we can think about the Montesquieu, but in current world, it might be a little bit different, especially if we think about the timeliness of the proceedings, about the delay of the proceedings, how we can cope with it. We talked with Professor Damsky about the delay of proceedings. We have also the problem with the delay of the proceedings, but we agreed that in Argentina it might be a little bit more difficult than in Poland, but it's different matter. The third thing is the diversification between judicial and administrative authorities. So the question is, if we may choose that some actions of the courts are judicial in nature, or maybe some actions, for example, the defining of the time of the hearing is administrative in nature, and if we agree with this, if for these actions may have the influence the administrative authority. The fourth thing is the competences of management authorities. So how management authorities can interfere on the judges. So what, for example, the president of the court or the minister of justice may do with the concrete thing, with the concrete judge. And the next thing is the possible influence on the court and judges, which is affected by the actions, for example, of the president of the court or the minister of justice, the executive power in general. And I will show you about on the examples from the Europe, the shape of management of judiciary from comparative perspective, from the European perspective, how it looks like in Europe. And at the end, I will show you two cases, two sentences of the courts, which is about the administrative activities of the authorities which supervise, which administer the judicial power. As I said, in general, in Poland, the choosing of judges, not only the Supreme Court or the Supreme Administrative Court, but also the Common Courts and the Administrative Courts, in general is the same. We have National Council of Judiciary, which is in which seated 15 judges, and President of Supreme Court, President of Supreme Court, 4 parliamentaries from Sejm and 2 parliamentaries from Senate. So the majority are judges, and they choose the candidates for the judges, and the judges are appointed by the president. But if you ask, the problem is about the composition of the National Council of Judiciary. In 2015, the act about the National Council of Judiciary was changed. Before 2015, these judges who are sitting in the National Council of Judiciary were selected by judges. From 2017, the act was amended, and right now these 15 judges which are sitting in the National Council of Judiciary are elected by the parliament. It was the great So that right now it is a great discussion because the European Union especially, but also the European Court of Human Rights criticized this method of choosing the members of the National Council of Judiciary. And probably right now, after the election, we will back to the previous model. So we will back to this model when the National Council of Judiciary was, in majority, of course, was chosen by judges. But in general, if you ask the candidates for judges, because of course the act of nomination is granted by the president, but the candidates of judges are elected by the National Council of Judiciary. But the point is who elects the members of the National Council of Judiciary. So that's the point, and that was the biggest point, I think, about the conflict between the Polish authorities and the European Union, and of course the criticism from the European Court of Human Rights and European Court of Justice, the Union Court. Coming back to the beginning, the role of judiciary, as I said, from my perspective as the judge, is the protection of the rights of individuals or of the society. And the most important is how to understand this protection of the rights of individuals. The most important is the effective judiciary. But we don't know exactly what is effective judiciary, how we can understand it, and so on. So we can understand it at the two levels, from my perspective. First, the organizational level. So how it should be the courts created, how should be the division in the courts created. Is it really important if, for example, we have administrative courts and common courts? I think yes, but we can discuss it. And the second level is the effective court proceedings. So this is also a problem with the inflation from the perspective. Yes. That is also the problem. But if we speak about the effective judiciary, we have also think about the independent court. And independent court is the court which may conduct the proceedings without any influence, especially from the executive court. If you ask for the nomination of the judges, it was also the debate if the nomination process, which is connected more or less with the parliament, because the parliament choose the members of National Council of Judiciary, it was also the statement that if we have judges which are elected by the National Council of Judiciary, which is chosen by the parliament, these judges may not be independent. But of course, the effective judiciary, the most important component of the effective judiciary is the independence of the courts on the different levels of the courts, but also on the level of concrete judge. Moreover, the court should be equipped with the tools which are necessary to proper perform that functions. And we can understand it also on the general level, on the direct level. The general level is about the legislation, about the allocations of the vacant positions to concrete courts, to allocation of the sources, especially the material sources, the assistance of the judges, and so on. And the direct level is the level of the concrete court. So in every court, probably the same like in Argentina, there is the president who allocates the cases, who allocate the court personnel to concrete judge, technical aspects of the functioning of the courts. The fourth thing, if I think about the effective court proceedings, is that this proceedings has to be fair. Of course, we can discuss what we can understand as fair proceedings, but in general, we understand it as they're conducted by the professional judges, which is fair if we speak about the proceedings, and the rights of the parties during these proceedings are respected. And the second thing, which I think is the special key in Argentina, but in Poland as well, that the effective court proceedings is resolved in reasonable time, so without unnecessary delay. Okay. Yeah, and most important from the perspective of administration of judges are two principles, which I said before. The first one is the principle of judicial independence. Of course, I think it is possible that in every court there is the administration, for example, the president of the court or the minister of justice even, which may have the influence on administrative activities of the courts. But what is really important that this scope of administrative management or even the supervision, because we can think about the competences of administrative authority in the courts, if they manage the courts, or maybe there should be some authorities which are the supervisory authorities over the courts and actions, but only administrative actions which are conducted in the court. And in Polish legal acts about the organization of the common courts and the administrative courts, it is clearly stated that if we speak about the administration of the courts or even about the supervision of the courts, these activities of administrative authorities cannot encroach on judicial activities. So, for example, the Ministry of Justice or the President of the Court cannot encroach into the proceedings. It is impossible. Of course, sometimes it might be hard to divide what is administrative activity and what is procedural activities. The second principle is the principle of separation of powers, and we have also the discussion how we can understand it if we speak about the administrative activities of the courts. So first of all, we can assume that the legislative or executive power cannot interfere into the decisions on concrete cases. And that's the most important from the judge's point of view, that it is impossible to interfere into concrete proceedings. But the question is, if it is possible that we can assume that there is a clear separation of judiciary between the executive and judiciary power. From my perspective, I think that there is no need for the separation of judiciary from other authority, but only if we speak about administrative actions. So, of course, we can, starting from the Montesquieu rule, that we have clear separation of powers. But if we speak about administrative activities, about allocation of cases, about the allocation of sources, I think there is no need about the separation for the separation of judiciary. What is important and what is discussed in Polish legal perspective, that this word, the superiority or subordination between the, for example, the Minister of Justice and the courts, it is not a good word, because court, if should be independent, cannot be subordinated, for example, by the Ministry of Justice. But if we speak about the administration, it might be connected between the, for example, the President of the Court, who should allocate the personnel to the judge to allocate the material services. And there is no legal prohibition or the obligation of establishing the authority which is established by the managing of judiciary. So in Polish Constitution, it is not clearly stated if we should have any authorities which are responsible for the administration or even for supervision by the common courts. And the next slide. And if we think, I don't know how it is in Argentina, we can discuss it, but if we speak about the administration of judiciary in Europe, we can divide it for three models. The first one is internal, the second is external model, and the third is mixed model. This is the model of administration of concrete courts or concrete branch of judiciary. The internal model is in general connected with the judiciary. So the administration of judiciary is conducted by the judges, more or less, for example, by the National Council of Judiciary, which is composed from judges elected by judges, or by the President of the courts, which are elected by the judges. So in general, there is the self-government model of administration. There is, of course, advantages and disadvantages of this model. The first advantage is more independence of judiciary. There is more or less clear separation between the executive power and the judiciary. But, for example, we can think that the disadvantage of this model, there's no influence for any irregularities or, for example, the delay of proceedings by any other authority than judicial body. The external model is totally different one, that we have, for example, the special agency or the Ministry of Justice, who is the supervisory authority and exercise the administration or the supervision. Then we have the problem with the independence of justice, because the Ministry of Justice or the President of the Court, which is appointed by the Ministry of Justice, may have an influence on the judiciary and, for example, may harass any judge which is not comply with the political option of the Minister of Justice. But from the other side, of course, we have the advantage, which is the influence of the executive power on the judiciary, especially if we come back to the problem of delay of the proceedings. So that's the point. And the third one is the mixed model. More or less, we have this mixed model in Poland that the administration is exercised by the authorities which are partly from judiciary and partly from the executive justice. And as I said at the beginning, we can show it on the different countries, on the models from different countries. I choose 4 countries: Germany, Italy, Denmark, and Poland. And in Germany, we have models which is more or less mixed. Of course, Germany is the federal country, so we have different models in different landes, so different provinces of Germany. But in general, the model of administration is connected with the Ministry of Justice of concrete provinces and the President of the courts. Different model is in Italy. They have the National Council of Judiciary. That's the mixed body as in Poland. But this body, the National Council of Judiciary, is composed by judges elected by judges. So it is totally independent. This is the example of the internal mode of court administration. In Scandinavian countries, we have here Denmark as the example. There's totally different thing. So they established a special agency which is independent. Of course, it's elected by the executive power, but in general, if we speak about the squad and the competences of the Danish court administration, it is independent institution which is responsible for management and development the Danish court system, and so it is a little bit different. And in Poland, we have the mixed system. As you see on the slide, we have, as I said before, 2 main branches of the courts. We have administrative court and common courts. And in administrative courts, which are totally divided from the executive power, we have the President of Supreme Court, who is also, apart from that he or she, but right now he is the judge of Supreme Administrative Court. He is also the general authority of administration and supervision of administrative judiciary. And on the lower level, we have president of lower courts of voivodeship administrative courts who conduct the direct management and supervision. In common courts, it is a different situation, and this is the reason of also the tensions between the executive power and the judiciary, because the general supervision over the common courts is conducted by the Minister of Justice. The Minister of Justice, of course, is the politician. He is the member of the political party. And for the last 8 years, it was the big tensions between the Minister of Justice and the judges associations, and judges who are not comply with the political view of Ministry of Justice. And the second level of the administration of the court are the presidents of the courts. Right now in Poland, we have also the system which show that the Minister of Justice try to encroach his competences, because the president of the courts are elected by the Minister of Justice. So the Minister of Justice, of course, has the strong power to speak about the supervision and administrative of the courts. So as you see, there are 4 different legal systems, and in these 4 countries, it is chosen the different system of administration, and this system of administration has the influence for the independence of judiciary. Yeah. And about the case law, because I think that it is clearly visible on the examples. I would like to show you two sentences. One is from the European Court of Human Rights, but it is the Polish case about the Polish court president. And the second one is the case from the Voivodeship Administrative Court. The first case is about the applicants who were the vice president of the common courts and were removed by the Minister of Justice without any reason. So the Ministry of Justice sacked two vice presidents of one of the common courts in Poland. There was the special act in 2017, which led the Ministry of Justice for 6 months to make the totally changes of the administrative authority in the common courts. So that for 6 months, the Ministry of Justice has the right to appoint or dismiss any court presidents in Poland, and he used it. So the Ministry of Justice decided to dismiss, as far as I remember, 300 presidents and vice presidents in Poland. And two ladies, Ms. Broda and Ms. Bojara, decided to go to European Court of Human Rights. And European Court of Human Rights decided that it is connected with the independence of judges. So the independence of judges is connected with the position in the court, and European Court of Human Rights claimed that it is necessary to ensure the security of tenure, that if the Ministry of Justice would like to dismiss the court president, it should be reasonable, and the court president should have the right to appeal for this decision. In Polish legal system, it was not possible to appeal. But also, what is really important, if we speak about the administration and supervision over the court and judges, the European Court of Human Rights claimed that this power of executive authority may have influence for the independence of the judges. So if the president of the court is also the judge, the dismiss from the position of the president or vice president may have an influence for the judicial independence. So that was the first of judgment from the European Court of Human Rights. And the second one, I know the letters are quite small, but I can explain it. The second one was the case which is connected with the composition of the National Council of Judiciary, because some judges claim that if in the first instance the judge who is elected by the National Council of Judiciary in the new shape give the sentence, there is the major break of the procedure, and the sentence in the first instance should be annulled. And it happened in one case of the court in north part of Poland, and the president of the court in Olszanowski, I don't remember exactly the name of the city, but it doesn't matter, decided to order an immediate break of the performance of the judge. So there is the special right of the president of the court. So, for example, when the judge maybe the crime is, I don't know, maybe drive after the alcohol, he can make an immediate break. And the president of the court, which was appointed by the Ministry of Justice, decided to order an immediate break of the judge, who gives the sentence, which annul the sentence of the first instance court. And the judge who was the subject of this action decided to go to the court, and Wojciech Administrative Court said that it is not the administrative actions, it was the break the rule, and it was the encroaching into the judicial activities. It was not the administrative activities. And Wojciech Administrative Court claimed that judge's independence in the performance of his office, and therefore he or she cannot be subject of any pressure and influence during the performing the judicial duties. Control of judgments may be also connected with the proceedings, cannot be the subject of the administrative activities of the administration or the administrative supervision. And this competence, which I said about, cannot be used as the instrument for interference of judicial activities. So it is impossible, but this case shows quite clearly that some competences of the administrative supervision and administration in general may be used as the influence as the tool which should interfere into judicial independence. And the last slide?
It's the last slide, I think.
Okay. So from my perspective,
Coming back to this judgment, from the perspective of administrative judiciary, I must admit that it's highly controversial because of this nature of the act given by the president of the ordinary court. On the one hand, we can present the reasoning, like my colleague, that it is an act that it's totally against the judicial independence. But on the other hand, we can also say that between the president of the court and each judge, there is an internal employee relation, and within this relation, there should be no space for appealing to.
Sorry, it's interrupted. Is it off or just too far? Okay.
Yes, I think that's.
So it's off. Sorry about that. No, it's on. No? Number 5. No. I know. Perdón. No problem.
So to sum up this plot, we can say that now we are waiting for the final resolution of the Supreme Administrative Court in this case. We will see. I can only tell you that inside the Supreme Administrative Court there are now quite strong debates about this case, and we had even a conference, a closed conference, only for judges and only for members of the Supreme Administrative Court, and the discussion was really quite active and deep. We will see what will happen, but it's also quite important to stress out that we have these two separate models of supervision over courts. And I think that according to opinion both of us, the system for administrative judiciary, it's much better because it protects the judicial independence in a better way. The president of the Supreme Administrative Court is responsible for this supervision. There is no competence of the Ministry of Justice according towards to administrative judiciary. So all those reforms that you heard from Poland concerned only the ordinary judiciary, not the administrative judiciary. And as we have some difficulties with the nomination of judges to ordinary judiciary, those difficulties are not present when it comes to administrative judiciary. Of course, we have the same judicial council, but in practice, the system of appointment of judges, it's not controversial because there are usually employees from administrative courts who are legal assistants or referendars who apply for the position of judges, and I have regular contact with judges from first instance or Supreme Administrative Court, and they tell me we have no doubts when it comes to new judges because we know them. They were our legal assistants, they were referendars, and it's for us quite understandable that after some period of time they become judges. Yes.
¿Puedo hablar así? Nada más para hacer un paralelo. Nada más que para hacer un paralelo que me permita comparar. Nosotros tenemos lo que llamamos un consejo de la Administrativa, tiene una clara influencia política. Constitucionalmente estaba previsto para hacer un funcionamiento equilibrado, terminó teniendo mayor influencia del Parlamento y del Poder Ejecutivo que los jueces elegidos por los jueces. Este Consejo de la Magistratura no solo selecciona, hace procedimiento de selección de jueces, con ternas en teoría vinculantes para el Poder Ejecutivo, pero que el Poder Ejecutivo puede decidir entre el primero, el segundo o el tercero de la terna libremente. Sino que eso no solamente es esa discrecionalidad, sino que tiene precedida de la acusación al Poder Judicial de ser una especie de familia que intenta renovarse de sus propios miembros, al respecto que se ha pretendido que las capas inferiores del Poder Judicial sean elegidas por sorteo público, en lugar de por capacitación de los empleados mínimos, porque los empleados mínimos o más tarde podrían ser elegidos jueces. Y la segunda cuestión crítica es cuando los magistrados llegan a 75 años, es el Poder Ejecutivo el que decide si se quedan o se van. Con la anuencia del Congreso, lo cual otra vez introduce al poder político por encima de la independencia del Poder Judicial, porque el juez depende de la relación Poder Ejecutivo-Congreso para saber si después de los 75 años, por más capaz que sea, se queda o se tiene que ir a su casa jubilada. Entonces, en ambos casos, tanto en la selección como en el control disciplinario de los jueces, la actividad aparece gravemente influenciada por el poder político. No sé si alguno quiere sumar alguna diferencia en el
Europa, Polonia ha tenido problemas por una cláusula similar. También tienen una decisión de jubilar a algunos jueces y otros no.
That's true. That during the last 8 years of the cadency of the time period of the governmental party who came to the end 1 week ago, we had serious problems when it comes to judges' nomination and also the tenure time. As I told you 1 minute ago, it concerns mainly the ordinary judiciary. For administrative judiciary, this process of nomination, although linked with this judicial council, is not so problematic because of the natural development of employees from the court to the judge's position and to the position of the Supreme Administrative Court.
Just to add about the age of the retirement, that it was 74, 75. We have 67, the age of retirement of judges, but that was another of lowering the age of the retirement. It was in 2018, and they started that they wanted. It was the attempt of resigning some judges who were older, but they quit. It was not happened in 2018. But the age of the retirement for judges is lower than in Argentina. But even though the 67 is the maximum, and some of the judges claim that these older judges are not capable to give the sentences. So that's the point.
If you have any other questions when it comes to organization of structure of the judiciary, perhaps it's now the right moment, because just after those questions, we will come to procedural issues. So please, if you have some questions to organization, then perhaps I will only supplement this presentation about the process of nominating the president of the Supreme Administrative Court, because the president of this court is a crucial person when it comes to organization of administrative judiciary. He's like the Minister of Justice. Yes? He can do everything within administrative judiciary. And he prepares the budget. He decides about the details when it comes to budgeting of particular administrative courts. The General Assembly of the Supreme Administrative Court nominates 2 candidates for the position of the president of the Supreme Administrative Court, and these 2 candidates are presented to the president of Poland, and the president decides who will be the next president of the Supreme Administrative Court for 6 years. Honestly, I was totally convinced 1.5 years ago that it will be a magnificent opportunity for the governmental party and for the law and order to overtake administrative judiciary without any troubles. Yes. When we had this election of the president of the Supreme Court, the rules were pretty the same, and the governmental party changed only one small detail in this procedure, namely the General Assembly of the Supreme Court nominated not 2 but 5 candidates, and then yes, and then the president had a bigger opportunity to nominate the president from the group of new judges, yes, who were nominated after the changing judicial council. But when it comes to administrative judiciary, it didn't happen. The parliament didn't change the rules of nominating, and the General Assembly chosen 2 candidates, and from those 2 candidates, the president of the state nominated one of them, and the president, the incumbent president of the Supreme Administrative Court is a judge for years with great experience. He was a president of one of the courts of first instance, and then president of one of the chambers of the Supreme Administrative Court. He has almost no with politics. Yes. As an employee in the Supreme Administrative Court, I can tell you that the former and the incumbent president are highly sensitive when it comes to politics. Yes, we have really strong recommendations from the president. No politics when it comes to representation of the court. Sometimes I'm asked by the president of the Supreme Administrative Court to represent him on some conferences, events inside or outside Poland. And every time we meet before this event, and he repeats me every time, Wojciech, no politics, no politics. I remember that 3 or 4 weeks ago, we had a delegation from the Supreme Federal Administrative Court from Leipzig, from Germany, and they sent us some list of questions concerning different topics. Among them, climate issues, how we cope with this climate challenges in Poland. And some of those questions were really addressed not to the court, but rather to the Ministry of Climate. And the president immediately told me, when you meet this delegation, please tell them that those questions they should address to the government, not to us. They can ask us about our jurisprudence, but not about the policy. Yes, we are not responsible for that. there is also a question why administrative judiciary has been not reformed by this government. Many people ask me about that. Administrative judiciary is much more important for government than ordinary judiciary. We decide about huge political plans of government, new roads, buildings, taxes, etc. And perhaps the answer why we are not reformed till now is this strategy of not being engaged in policy. Of course, this answer is very convenient for me as a member as an employee of the Supreme Administrative Court. Ordinary judiciary didn't have this choice, yes? The reform started immediately after coming to the power of the governmental party. So nobody asked them if they want to be reformed or not. We were silent from the beginning till the end. For some judges of ordinary judiciary, it's a charge against administrative judiciary. They repeatedly tell us, you should be more supportive against this conflict with government. But immediately the answer of the president of the Supreme Administrative Court is, it's not our task. And of course, there are some judgments of the Supreme Administrative Court that they can be treated as pro-governmental because they are in line of government. But in the same time, we have also judgments that can be treated as anti-governmental, yes? I'm totally against such kind of classification that one of judgments is pro or against, yes? Definitely, I can tell you with 100% convenience that that the administrative judiciary and the strategy of administrative judiciary is as neutral as possible in this complicated situation that we have now in Poland. But coming to the procedural issues, we have. I would like to discuss with you three subtopics: public hearings, court transparency, and current challenges for the Polish administrative judiciary. When we discuss the issue of public hearings, then immediately we have four possibilities. Public hearings, it means physical hearings, when all of participants are in the same room and they have this contact with each other. The second form, online hearings, especially during the pandemic. Only the court is inside the court building and the other parties are, one is in Argentina, second is in Peru, and the third in France. Then we have mixed version, hybrid hearings. Some of the parties are inside court buildings and some of them are outside. And the fourth form, in-camera hearing. It means no public hearing. The judge decides the case alone. We usually say in Poland, in his own office, without any influence from outside. There is, in this case, we have only a written procedure, and there is no contact between parties to the proceeding. So four possibilities. In Poland, the principle of public hearings is one of the most important when it comes to the right to a court. And in our constitution, we have this right stipulated as a right to a public hearing in a reasonable time. Yes, so public hearings play a great role in each court procedure. Public hearings are also typical, I think, for the whole European culture when it comes to judiciary. From Jeremy Bentham, the famous English philosopher, we hear publicity is the very soul of justice. And from the jurisprudence of the European Court of Human Rights, we can hear courts cannot operate in a vacuum. So we can ask a question: if a party has a right to the proceeding in a physical way or in online, how we can model this right to public hearing? Must it be only physical, or can we change the form of publicity into this at least online or hybrid form? The second question is if the nature of public hearing is the same for administrative, criminal, and civil courts or not. My opinion, not. And the third question is to what extent can physical hearing be replaced by in-camera hearing? Coming back to the first question. So the first question, has a party to the proceeding a right for a physical hearing? 2 years ago, we had quite famous judgments of the European Court of Human Rights, Yellow against Norway. It was a case connected with family issues. Mr. Yellow, a Gambian citizen, didn't receive a permission to come to Norway to participate in proceeding that was focused on the right to children. Yes, children's rights. Had two kids in Norway, and he wanted to apply for the right to contact with those children. And as I said, he didn't receive this permission to come to Norway. Nevertheless, he wanted to participate in this public hearing in physical form. His reasoning was focused on this right to physical hearing because then he had a better opportunities to change the reasoning, to react on the judge's questions, etc., etc. And in the final judgment, of course, the right was refused to him, and he appealed against this final judgments of the Norwegian Supreme Court to the European Court of Human Rights. And this court, the European Court of Human Rights, stated that the right to a public hearing is not absolute, and that the applicant had a real possibility to participate in public hearing in online form. And this online form, according to this European Court of Human Rights opinion and judgment, was sufficient for him to present his reasoning and to fight for his rights. So the question on the first, the answer on the first question is, there is no absolute right to a public hearing in physical form. The second judgment of the European Court of Human Rights is quite interesting, mostly for us, for researchers, because it's a Slovenian case, and a case when a Mirovni Institute, so some research institute, applied for funding from Slovenian Ministry of Higher Education, and they didn't receive this funding for the research. In Poland, it's also much more important, significantly much more important, to apply for external sources for research. If you have external sources, you can, for example, travel to Argentina. If you don't have, you have to stay in Poland and only organize your research from Posznan. Yes. So in Slovenia, I assume it's the same situation. They need to apply, and they got negative decision. They applied against this decision to the administrative court in Ljubljana with a request for a public hearing. But according to the Slovenian procedure, before administrative judiciary, there was no possible to organize such kind of dispute public hearing. The court dismissed the application of the Mirowni Institute, and this institute then decided to appeal against the final judgment to the European Court of Human Rights, and then the European Court of Human Rights not quashed, but of course founded the violation of the Article 6 of European Convention in this case, but not because of the lack of public hearing in this case, but of the lack of sufficient explanation. It's quite important. The European Court of Human Rights stated that in proceedings before two instances, at least one instance must, in general, provide such a hearing, public hearing, if no such exceptional circumstances are at hand. Then the European Court presented some examples where, in which cases it's possible to resign entirely from public hearings. And at the end, the court stated that perhaps this case will be also in this way, that public hearing would be not necessary, but the court didn't explain in a sufficient way why the public hearing, according to court understanding, was not necessary in this proceeding. Yes. In my opinion, public hearings before administrative courts, generally speaking, are not so important like before civil or criminal courts. Why? Administrative courts are focused on control over public administration. The control is based on legality of public administration. In practice, we get at the beginning of each court administrative process a big, huge material from administrative procedure. And it's quite different, like with my colleague Jan, because he started to produce the material at the beginning of civil process. We receive the whole material, and our task is to control. In the Polish administrative judiciary, it's not possible to hear a witness before administrative court. It's not possible to hear an expert opinion or some inspection. The only way to organize discovery proceeding is to make an evidence from document. So according to this idea, the whole discovery proceeding should be organized and performed before administrative authority. And the only task of the court is to check if the administrative authority made it correctly or not. The witness and expert report should be appointed at the level of administrative procedure, not before administrative. If administrative court is an opinion that in this case there should be some witness heard or some additional expert opinion. Yes, exactly. Yes, only the review. In exceptional cases, the court can decide in merits. For example, we discussed it today. When the public authority is timely ineffective, party to the proceeding can appeal against this timely ineffectiveness to the administrative court, and then the court can oblige public authority to finish the case in a concrete time. But it's only one of those exceptions. In a general way, the judgments of the administrative courts have cassational nature. Similar to some cassation nature of the competences of the Conseil d'État, but not in all disputes, only in those disputes annulation. Similarly to German competences of administrative court, but also not in the whole part of adjudication. So why the administrative courts in Poland don't need public hearings? Because generally speaking, they don't have discovery proceeding. Public hearing is responsible to meet with a witness, to show in the eyes of witness, not only to hear what he or she say, but to observe him or her, to see the behavior, yes, of this person. We don't have this kind of possibilities before administrative courts. And in my opinion, it will be fully sufficient to organize a written procedure before administrative courts. For example, to ask parties for some extra explanation of the case in a written form, yes? Now we also face the challenges of digitalization. Then we have additional possibilities, how to improve the speediness of the proceeding using these digital methods, yes? Court transparency. I know that you're exhausted and I promise 5 minutes on it.
It's very easy.
If you have any question, feel free to interrupt me and to ask me. Court transparency, 4 subtopics. I will only mark them, but if you have any additional questions, feel free to ask. The first, publicly accessible databases of jurisprudence. It's the first feature of court transparency. If a court wants to be transparent, the jurisprudence of the court should be highly and widely accessible. And we have in Poland an administrative judiciary, a searching machine of all judgments of all administrative judiciary, and this machine is accessible for all citizens. So everyone can click in computer on the website of the Supreme Administrative Court and find with this search machine almost every judgment of this court.
Searching process is easy.
It's easy, quite easy. You can choose, for example, the name of the court. You can even search for this judgments of words, or name of a judge, or symbol of a case, or you can combine everything. Yes. For example, I usually present this basis to the students, and to show them how it's easy, I try to type on the computer quite popular formulation and show them, yes? For example, sometimes I choose Jesus Christ, yes? I Jesus Christ, and then I get some judgments with this formulation, Jesus Christ. And there are 2 possibilities of having Jesus Christ in the judgments of the Supreme Administrative Court as a known own name, for example, a hospital of Jesus Christ. Yes. And the second possibility, when judges try to cite Bible, sometimes it's not so. It's quite rare in Poland. It's quite rare, but nevertheless, there is a possibility. For example, yesterday I heard in a church one of histories when Jesus said, "Give what belongs to God, and what's to Caesar to Caesar." And we have one judge of one of administrative courts who likes this lot from Bible, and in the tax cases he usually wrote when there is highly complicated case. Okay, it's a tax case. Money are from the state, so please pay. Yes. So it's very useful, this searching machine, very useful. The second possibility of creating court transparency, it's court presence in media. What can we develop under this headline? First of all, internet websites of courts. And here I will also only tell you that I asked my two PhD students to compare some internet websites of selected Supreme Administrative Courts. It was a small project held at our faculty. Their task was to compare the website of the Polish Supreme Administrative Court, German, and from the UK. It was quite interesting because then we saw interactive versions, websites with, for example, with announcements of incoming trials, with some recordings, with judges' profiles, with some movies. For example, the website of the Conseil d'État, it's very informative because there are even some movies for kids at the website, yes? Or traditional version, like in Germany or in Poland, no movies, no judges' profiles. The court is opened from 8 to 4. Stop, full stop, yes. The second option is the presence of judges and courts in media and social media. It's highly controversial. Honestly, my presentation on Friday during the conference will be about the presence of judges in social media. When I discussed this area with my colleague Jan, he's totally against, he's a judge. And according to his opinion, there is no option to present judge's opinion in media. I'm not the judge, so I have more liberal opinion. I think that judges should be present also in social media. But this topic we will develop on Friday. Of course, if you have any questions, feel free to ask. And the two last headings, court's press service, it's also quite important. And the question is how to build the press service of courts. Should the press service be only composed of judges, or judges of journalists, or only journalists? We have many advantages or disadvantages. And the last thing, plain court language. It's also quite important. And another of my PhD students also had a project to compare the language of the Supreme Administrative Court and the French Conseil d'État. And 3 or 4 years ago, the Conseil d'État introduced special rules for judges how to present their reasoning. Short sentences, no commas, quite uncomplicated way, and the Polish counterparts. 5 or 6 lines with the same sentence, yes. Almost no recommendations for judges how to use the language. It's also quite important because many citizens have no idea about the language, the legal language, and I think that for the majority of the society, I assume that the same is in Argentina, people do not have any sense of law. And then they can be quite easy manipulated by populists and by other citizens who are not objective, who want to win on the criticism against courts.
The UK Supreme Court is on this way of simplifying the language since 2010, for example. And we have a research institute inside what we call el Consejo de la Ciudad de Buenos Aires, Justicia de la Ciudad de Buenos Aires, about simplifying the language of the courts. No? el Consejo de la Magistratura de Buenos Aires, exclusivamente dedicado only this with the only focus on.
So perhaps it could be our common area of research because we are also highly interested in this topic. I think it's quite interdisciplinary because not only lawyers, legal linguistic can also participate, and
especially in administrative law, because the relationship between the administration and citizens has got to be with lawyers, no? And then the simplifying of languages.
yes, I agree with you.
There is a progressive and deep movement of lawyers, mostly left-handed lawyers, which I describe, fighting for the democratization of the legal speech. There are also not a large number, but some decision of the Latin American Human Rights Court and establishing some certain parameters towards achieving this. The legal languages should be clear, concise, and the sentence should be briefly presented. There's a lot to be said about this, but let me point this thing out because this is a very controversial issue in which we both Latin Americans and Europeans have a lot of points in common. A very large task.
Yes, it's highly controversial because, for example, our judge can answer us, I'm very sorry, I'm a fully independent judge. Nobody, and special legal linguistic, will tell me how should I. Yes.
I can give you one example of my course. There was the lady who conducted the process. Is it okay now? I can give you just one short example from my court. There was the lady, she's the judge, and she conducted the proceedings. There was the proceedings with one party, one lady without any advocate, so without legal representation. And she gave the sentence and she justified the sentence, and she told me that she justified the sentence for 15 minutes, and she explained this lady what happened in the court, and it was all the lady, and at the end she asked her, Your Honor, I lose or I win? After 15 minutes of justification, and she came to the room and she asked me, am I stupid or not? So that was the point.
Coming to this, I would like that one professor that is here and is also judge can take the floor in order to explain how this problem takes place mostly in
Somos un poco conocer
bueno, yo considero porque yo creo que estamos estudiando aparte, porque toda persona que llega a ser magistrado, también es un examen escrito. Ese examen escrito debe ser planificado por utilizar que se atiendan que tienen la idoneidad suficiente para ver si ese examen está calculado en una cantidad de puntos. Entonces, el problema del lenguaje ya no termina siendo después una regla que se tenga que imponer, sino en el momento que vos elegiste o planificaste el postulante, vos ya sabés.
Sí, yo tengo una respuesta para eso. Yo creo que una vez elegido juez, puede ser que se ponga de maneras, Todavía el juez puede ser capacitado para llegar a la gente de manera más simple. Sobre todo porque la labor del juez no es solo de historia, sino también pedagógica. No pretende enseñarle a la gente dónde está el derecho y cuáles son los principios básicos del derecho. Es todo lo que escriben con letras comunes, si no se escriben con letras difíciles y con latinazos, con palabras en latín y aforismos, o si no, con las palabras comunes de la gente.
Coincido 100%. Lo hoy es que si creemos que esto se va a cambiar, sería una discusión mucho más profunda. Si creemos que esto se va a cambiar por una directiva, de qué manera se tiene que escribir o no, me parece que el cambio proviene de otro lado, que justamente quiénes son los recomendaciones del suelo. Y el principio, por ahí, de esto, está siendo lo que discutían anteriormente. Llega a ser juez, el que viene dentro de la justicia, que está dentro de la familia judicial, o llega a ser juez la persona que es la jueza. Para ser juez, ¿cómo lo califico? Se califica igual el abogado que viene de la matrícula que viene dentro de la justicia. Hay algunas pautas subjetivas de calificación a los exámenes que los aspirantes a jueces realizan. Cuando se califica un examen, una sentencia, se ve un resultado o se ve si hay un razonamiento, si se planteó una tesis, se puso argumentos, se pusieron contraargumentos, si se tomó el precedente. El precedente se aplica como tiene que ser aplicado por el solo hecho de igualdad de hechos. Voy a aplicar un precedente por más que tenga. Digo, creo que es mucho más profundo que bastar una línea de cómo escribir, y se resta lo que llevaría muchísimo más tiempo que directrices. Además que coincido que tiene que haber un cambio, pero no creo que la solución del cambio sea bajar las directrices, sino ver qué justicia queremos y cantidad de las cosas son.
It is very important to introduce the position because who has judge is the judge, is the federal judge. The professor and also the professor of administrative law, Dr. Walter. So it's important because this is that we are holding a huge controversial here in our country and in most of the Latin American countries. Regarding this, and the position are not clear and not possible.
I agree.
Por favor. Sí,
In Argentina, what the inflation is bueno, es precario.
¿El qué?
En
Argentina, most education is still the same, but precarious.
En América Latina también, en
And
general.
as well as in Latin America overall.
Y a mí me parece importante
So it is really good
que el lenguaje sea más sencillo, porque para los jueces encontrar más difícil, pero creo que es más fácil para que hablar sencillo que para la sociedad, sobre todo un lenguaje más complejo. Es más fácil bajar el inglés en la comunicación de los jueces siempre simplify the language to accept el lenguaje legal.
El campo pues, que tenga la capacidad de hablar sí.
Por favor.
Ahora esto lo estoy viendo porque hoy hace un rato donde venía de trabajar están explicando justamente en la judicial cómo para hacer las resoluciones hay que simplificar el lenguaje para que vamos a ir de manera más sencilla y que después sea más sencillo para la comunicación en general juez, entre el defensor y el fiscal, y que eso pueda ser conveniente para las personas, sobre todo cuando hay imputados por medio, bueno, yo justicio de la parte fiscal, pero para que también las partes que están implicadas en ese juicio puedan entender y puedan tomar decisiones y intervenir de una manera más sencilla, entendiendo cómo se van dando las circunstancias.
Yo lo que quiero agregar es que si esto es grave para los jueces, es mucho más grave para la administración. Porque la administración, tanto en las leyes que se dedican a la administración como en las resoluciones administrativas, están destinadas a lejos, a personas que no tienen capacidad jurídica. Entonces, después se le pone trampas en las que caen porque no se atiende lo que se necesita ni en la ley ni en la resolución.
Profesora Bárbara Fernández Villa, que no la presenté, y deberíamos.
No, pero bueno, pero le parece claro, importante, en Argentina, la Facultad de Derecho, en la parte de Argentina.gov.ar, Judicial, hay todo un sitio de claro, son varios manuales, instrumentos, sobre todo para el empleado público, el empleado judicial, para la tiempos activa, o sea, sencillo, ¿no? Sujeto, verbo predicado, evitar la actividad de verbo, como decir, se debería, proceder, como pudir, se construye, no sé, como achicar la cantidad de textos de los puntos, aquí no van a ver que ya estamos trabajando, ya la cosa como concepción, sobre cómo redactar las patentes de modo comercial. Yo dije, no me lo muy claro,
Profesor Román West.
Solo quería agregar, acompañando un poco lo que decía el doctor, que tenemos que estar muy atentos todos los jueces, todos los abogados, porque en el Estado hay implementado algo que suele dar la tecnología burocrática de la complejidad. Que todo sea complejo para que la administración pueda entender y me calcule el derecho. Además, está extremadamente al borde de dejar de funcionar. Es una técnica extremadamente utilizada por el Estado, complejizar para que la gente no lo pueda entender. Es una caja negra de nadie entendida. Algo simple al servicio del administrador. Y lo han llevado cada vez más pasando que sea una caja negra donde se le da resolución tras resolución, más decreto, más ley, se convierte poco entendible para los administradores y a veces hasta para los propios abogados. Por eso, tanto los abogados como el banco están en la administración, tienen la función de volver a especialmente con esa de la administrador.
De acuerdo a la reglamentación de la Ley de Procedimientos Administrativos, para notificar a un ciudadano la negativa de una petición, el rechazo de una petición, hay que decirle, es necesario decirle qué recurso puede interponer si se agota la vía administrativa. Se supone que eso es en beneficio del particular, del ciudadano. Sin embargo, no le dicen que si no interpone los recursos a tiempo o no va a la vía judicial, pierde su derecho. Es lo único importante que había que decir. Entonces, la verdad es que la ley no significa lo que tiene que significar, decide lo que le pasa. No, qué alternativa jurídica tiene cuando en realidad lo que le importa es el derecho al sitio pierde.
So the case law in the occurred in the south, Patagonia, it's a kind of well known because the case of family law was a judge in biological very famous in America, and she decided to write the sentence in technical terms, but in the resolutive part, she explained it very easy, very easy way to examine children of 14 years. It was connected to, I don't remember, but it was connected to some adoption or something like that. And she told, okay, now this is going to be your father, this is going to be your mother in a simple way. It was a sentence we were praised in our country. It's connected to what the doctor said. Sometimes people know what the judge is trying to tell them. So I think it's interesting to bring this one closely connected to the constitutional right to be back to justice at some point. But I also understand that there are some technical aspects that need to be written. Well, yeah, written the sentence. That's all. I can go through the case law.
Go ahead.
Thank you very much for all your remarks. I think that there is no one easy answer to those tensions. On the one hand, we need the precise reasoning of court judgments, and sometimes it's difficult for us to prepare to shape this reasoning in a simple way. For example, it's not only an issue of judges' reasoning or court's reasoning. It's also an issue of scientific reasoning. When I write a paper and a journal will approve it, or a book, after some time I receive this paper with linguistic comments. And sometimes I'm really furious, because according to my impression, this person, this linguistic officer who wanted to help me to make my paper more understandable, he or she makes it in so irritating way that it's hard to imagine for me how should I cope with it. Yes, sometimes the sense of my reasoning is totally different according to this linguistic opinion. Yes, I really don't like it. On the other hand, I don't want to be impolite. Yes, sometimes I really have this will to answer. Please do not change everything. Yes, do not change everything. But then I try to understand that it's also quite beneficial to have this correction. Yes, from the perspective of courts, so there is. We should also formulate one question: who is the addressate of the court reasoning? For whom we write it? Judges of lower instances, they will answer immediately. For the court of the higher instance, because I was also a legal assistant in the administrative court of first instance, and I heard that many times. Please use the sentences of the Supreme Administrative Court in our justifications in order to make stronger our reasoning. I discussed with some judges many times if we can make the reasoning shorter, more compact. And usually the answer was no, because there is the Supreme Administrative Court. Judges in the Supreme Administrative Court, they can, of course, write more compact, yes? We not. We are under the control, yes? But I'm also not entirely convinced that the dismissal of the judgments of the lower courts is always detrimental for this judge. I'm not so convinced. I think it's our thinking, Polish thinking, yes, that my judgment should be upheld by the Supreme Administrative Court. I should defend my reason. Of course, you should defend as a judge, but if your judgment will be quashed, there is no tragedy. Sometimes it's necessary for development of jurisprudence. It's necessary for making it more professional. But in our legal thinking, we are scared about it. Perhaps there is also a solution that the most important judgments of the courts of highest instance should have two explanations. One, this legal explanation for the legal reasons, and the second explanation without binding force for the ordinary citizens, for the journalists. I have also this experience with journalists. They sometimes entirely don't understand what we talk to them. I remember 2 or 3 years, I gave an interview to one of newspapers in Poland, and I asked at the end of this interview, please send me the final version of my, for authorization reasons. And it was God's blessing for me, because the first version was totally different with this sense what I told to this journalist. So they don't have, a normal journalist doesn't have any education in law. In Norway, there is a practice quite interesting, that there are some judges, retired judges or judges who are still in office, and they offer their assistance to journalists. At the website of the National Council Administration of Judiciary, Norwegian, there is a list of those judges with phone numbers. And every journalist can phone a judge, one of those judges, and ask for a meeting, for some consultations. Once a year, the Norwegian Supreme Court meets with journalists like we here and discuss with them the current issues of the jurisprudence, the current problems, what should we improve or change, yes? I think that the dialogue between various professions is quite important. We should discuss with us, hear our reasoning, and once again, unfortunately, the Polish experience, the Polish legal culture is based on fear. Yes, it's based on fear. Not only when it comes to judicial affairs, when it comes to the whole life, we are feared. For example, I think that the main reason for this 8 years of governmental party who destroyed, at least to some extent, the legal order in Poland, it was based on fear, yes? We should defend our country against the EU. We are sovereign, yes? We should defend our country against migrants. If the opposition win the election, then immediately we will have many refugees from Arabic countries, and they will destroy our country. Yes, Poland is quite unitary country when it comes also to citizens. Yes, so, and such kind of threats are really difficult for us.
Yeah, friends, we need to finish because of the time. And I'm so sorry for this. I would like that Professor Fernando Wojciech do the closing of our meeting and hoping that this is the first of several meetings that
Okay, so
you know,
please 10 seconds. 10 seconds.
yes.
Because we have to do some there is a book in English about all branches of Polish law. A comparison, yes, a short version of all Polish law. Foundation prepared at our faculty in Posznan. The second thing that we have for you is some presentation of our law faculty. And the third thing I have share all legal text when it comes to administrative judiciary. So I will give it to you.
Ahí apaga el micrófono.
¿Cómo se apaga? ¿Cómo se apaga?
Se apagó.
Acá, ¿viste?
Creo que ya no